Good afternoon. My name is Linda Jellum, and I'm a professor at Mercer University School of Law. I've been teaching statutory interpretation for 17 years now, and I'm here to talk to you all today about the panel that we did here at the conference titled Iustum Generis, Statutory Interpretation for Lawyers. Now, I don't have time to do the entire hour-long presentation, so I've tried to decide what is most important for you as a new lawyer to take away from what we discussed. So I'm going to give you a 6-step process on how to approach a statutory interpretation question or issue. I'm going to warn you in advance, I cannot cover everything that we talked about on the panel or even everything that is out there in the statutory interpretation world. All right, let's start with step 1. Step 1, it's absolutely essential that you as the lawyer identify the language of the statute that is at issue. And that language must come from what we call the operative section of the statute. That is the part of the statute that provides the rights or the duties. The thou shalt, for example, or thou shalt not. From that operative section of the language, you may need to branch out. For example, has the legislature defined the particular term that you're going to be talking about? Or is there an exception to that particular term? Let's assume and take as an example a case called Kentucky versus Plowman. In this case, the defendant set fire to a bulldozer and he was charged with arson. The operative section of the statute read, a person is guilty of arson in the second degree when he starts a fire with intent to destroy or damage a building. Building was defined by the legislature in the same act as building specifically includes any dwelling, hotel, commercial structure, automobile, truck, watercraft, aircraft, trailer, sleeping car, railroad car, or other structure or vehicle. So our language at issue in this case ultimately comes from the definition section, but we could only get there by starting with our operative section. We're interpreting the word other vehicle. What does that mean? All right, we've accomplished step 1. Now we need to move to step 2. Step 2 is you need to identify multiple possible meanings. Most importantly, what does your client want that language to mean? So let's think about the defendant in the Kentucky versus Plowman case. The defendant is going to want other vehicle to mean those conveyances that transport people or persons. That's their purpose. Bulldozers don't generally transport people. Well, you must also think about what's the other side going to argue that that language means. And here the other side is the state. The state is going to argue that that language means any type of vehicle, regardless of what its purpose is. Well, now you need to prove that your ordinary meaning is the correct one and that the opponent's is incorrect. And generally today we do this by citing dictionaries to support that our interpretation is the ordinary meaning of the particular language at issue. All right, step 3. We've identified the language at issue. We've identified the 2 possible interpretations. Now we got to argue about what that language might otherwise mean. In other words, we might need to avoid the ordinary meaning. Some judges will not look beyond the text, beyond the literal language of the act without a reason. So I'm going to talk about 2 reasons today. First is ambiguity. Ambiguity just means 2 reasonable people would disagree as the meaning of the statute, or the 2 meanings are equally plausible. Another option is absurdity, that if we apply the statute as written literally, it will frustrate the purpose of the legislature to interpret it that way. Well, let's assume that the judge were willing to find that this language is ambiguous. It could mean vehicles to transport people, or it could mean any vehicles. Where do we point the court next? So this is step 4. Step 4 is we consider the other intrinsic sources. Intrinsic sources being those that are related to the text of the act or the bill being interpreted. I'm only going to talk about a few of these, but let's specifically talk about the one that the panel's named after, Iustum Generis. What is Iustum Generis? It's a fancy Latin word, makes us sound very smart, that simply means we define catch-alls and general words based on the language around them. So if we apply jus rem generis here, the words around the word other vehicle are automobile, truck, watercraft, aircraft, trailer, sleeping car, and robocar. They all share the common trait of transporting people or things. Okay, jus rem generis is just one linguistic canon. We also might apply impari materia and the identical words presumption. Impari materia tells us that we can look at the whole act itself or related acts within the code, and the identical words presumption tells us that if the legislature used the word vehicle or perhaps bulldozer in those other statutes, then that language should be interpreted identically. And sure enough here, there were other laws, traffic laws, transportation of hazardous waste materials, etc., in which the legislature had defined vehicles in a way that did not include bulldozers, and it specifically sometimes listed bulldozers when the legislature wanted bulldozers to be included. So those linguistic canons specifically help the defendant. All right, step 5. You're still moving on. Maybe we haven't resolved the ambiguity. So now we're going to move to extrinsic sources. Extrinsic sources are those sources that are related to the legislative process of the particular act. Legislative history, unexpressed purpose, drafting history, and here there's a very good argument for the state. The act originally applied only to dwellings where people lived and vehicles where people lived. In other words, the original act was meant to prohibit someone from burning a place where someone might be sleeping or otherwise engaged in living. But in 1982, the legislators specifically removed the qualifier on vehicles, so now no one had to be living in it for it to count as a vehicle. That shows that the legislature had broadened its interpretation of vehicle and wanted a more broad application of the act. Finally, we move to step 6. You still have ambiguity. We want to move to what we call policy-based sources, and these are sources based on the Constitution or prudential considerations. The most relevant one here is called the rule of lenity. The rule of lenity directs us to interpret ambiguous penal statutes in favor of the least penal option because of due process concerns. So the defendant has a very strong argument here that the least penal interpretation of this statute is that it does not cover bulldozers, and therefore a bulldozer is not a vehicle. All right, that's your 6-step process. So in conclusion, you want to follow that 6-step process to go through any statutory interpretation questions that you have. Again, recognize I didn't cover every source. There are a lot out there that might also apply to your situation. And finally, you might be wondering about the outcome in this case. Well, the defendant was convicted, and when he appealed the sentence based on the interpretation of the word vehicle, he lost, and he's still in prison. Thank you.